And
Yeah.
so we'll request you to speak one by one or ask questions as we interact. But sorry, okay,
So
all right,
I have a short, like 5 minute statement that I'll read, and then I can
yes,
send it
yes,
out to
yes,
you if you like. Yeah.
sure. All right, so
Mine
we are
might be a
live
little long.
now. We are live. We are live now. So let me start, and I'll just lay out some of the sort of the format in which we do these things. So my name is Munish Gupta, and I am the secretary of the Foreign Correspondents Club of South Asia, based in New Delhi. And welcome to all of you, our special guests and our panelists for this very interesting, promises to be a very interesting webinar on freedom of speech and the Indian judiciary. And to welcome our special guests and the panelists, I would like to request Mr. S. Venkat Narayan, who is the president of the FCC, to do a very brief welcome to everybody. And then after Venkat finishes, then we would request our three special guests to each speak for 5 to 7 minutes. I'm sort of giving you a ballpark time so that we get enough time for interaction after that. I've already started receiving a lot of questions. So we want to keep some time for questions and answers later.
Venkat
So
mentioned 10 minutes, so I may exceed your 5 to 7 minutes. Is that all right?
that's okay. I think I will give you my I will give my 3 minutes to you. I'm not going to take it off. But Venkat,
Thank
please go
you.
ahead. In the interest of time, go ahead.
Uh, Good afternoon, ladies and gentlemen. A warm welcome to the Foreign Correspondents Club of South Asia, webinar number 16. As you know, the Foreign Correspondents Club of South Asia is one of the oldest clubs in the subcontinent. Founded in 1958, we have 1,200 members who work for the global media and cover India and South Asia for the world's leading newspapers, magazines, and TV channels. Anything you read about India in the foreign media would have been by a member of the club. Now, because of the lockdown, we have been conducting these webinars, and they are being watched by people all over the world. And a warm welcome to all of you, Prashant Bhushan, Iqbal Chawla, and Arundhati Roy, and my fellow panelists, Munish, of course, Sanjeev, and Veer Raghav, Charu, and Simran. To introduce our distinguished panelist, Prashant Bhushan, I don't think he needs any introduction. He has not left the front page or the lead story on television channels during the past couple of months. And, he is son of a famous father who changed the course of history by unseating Indira Gandhi in 1977. So Prashant went to IIT Madras, left it halfway. Then he went to Princeton, that also left it halfway. And he came back and has a degree from Allahabad University. He has great interest in human rights issues, and he has so far handled 500 issues concerning poor people and human rights violations and things like that, and he does not charge anything. For other clients, he barely charges 5% of what the other lawyers charge, and we are delighted to have you with us, Prashant. Then we have Arundhati Roy. She needs no introduction. She became famous by writing her very first book, The God of Small Things. She has so far published 21 books. Two of them are non-fiction, and 19 of them are fiction. And she
Excuse
takes active interest in social issues. And she had been punished for all of 30 seconds not long ago by the Supreme Court. And we will hear what she has to say about freedom of speech and the Indian judiciary. Iqbal Chagla also is a very distinguished lawyer, studied at King's College, Cambridge. He is happy being in Bombay, son of a well-known father, the great Muhammad Ali Karim Chagla, who was Nehru's foreign minister, our ambassador to Washington, and or ambassador to the UK. Now, Iqbal belongs to a family of lawyers. His son is also a judge in the Bombay High Court. We are delighted to have you with us, Iqbal. Without wasting any more time, may I now request Prashant Bhushan to make his opening statement. Prashant, thank you.
Thank you, Venkat. As you know, as perhaps many of us know, uh, I'm glad that this contempt case against me has brought the focus not just on the law of contempt, but also on the issue of freedom of speech, as well as brought the focus on the role of the Supreme Court in the last 5 years. So far as contempt of court is concerned, it's broadly of two kinds. Civil contempt, which means disobedience of the orders of court. There is no problem with that because we need a sanction to ensure that court's orders are obeyed. Then there is the criminal contempt, which is divided broadly into two parts. One part is interference with court proceedings or interference with the administration of justice. So if you don't allow court to proceed, if you dance on a judge's desk, if you threaten a judge or a witness that if you decide this way or if you give this evidence, I will kill you, etc., that is clear interference with court proceedings and the administration of justice. But the third part, which is the second part of criminal contempt, which is scandalizing the court or lowering the authority of the court, which is what was used in my case, that's the problematic part because that is directly in conflict with the freedom of speech. See, that's a vague and undefined jurisdiction in which what is scandalizing, what is lowering the authority of the court, nobody quite knows. It is left to every individual judge to decide as to what is scandalizing or lowering the authority of the court. Anything that you may say against a judge or any criticism of the court may be treated to be scandalizing the court or lowering the authority of the court. In my case, for example, my tweets were about what I felt was the role of the Supreme Court in not protecting democracy in the last 6 years. Now, these are the kind of things that everybody in a democracy, every citizen in a democracy, most of all those who are familiar with the judicial system and the working of the Supreme Court, should be able to say freely. But unfortunately, that has also been treated to be contempt of court by scandalizing. And in this jurisdiction, the judge acts as the accuser, as the prosecutor, as well as the judge. So it's a very, very dangerous jurisdiction in which judges act in their own cause. And that is why in all civilized countries, this jurisdiction and this power to punish for what is known as scandalizing the court has been abolished. It is only continued in a few countries like India. And unfortunately, sometimes it is misused or abused by the judiciary in order to attempt to stifle the freedom of speech or free discussion about the judiciary. I'm not saying that there isn't sort of wild, scandalous or scurrilous allegations being made against judges. There are. But those are dismissed for what they are. People see them for what they are. People understand that these are wild, scurrilous, unsubstantiated allegations. The respect for the judiciary or the standing of the judiciary does not depend upon the ability of the court to stifle this kind of criticism, even if it is sometimes unfair and scurrilous. The standing of the judiciary and respect for it depends upon the actions of the courts and the judges. And that is why we feel that this should be abolished. In fact, Arun Shourie, N. Ram, and I had challenged this scandalizing the court or lowering the authority of the court. Initially, that case was listed before a bench headed by Justice Chandrachud, but thereafter it was removed from there and sent again to the bench headed by Justice Arun Mishra, whose views about contempt of court and scandalization are very well known. In fact, earlier on 3 occasions, he had accused me of having scandalized the court or committed contempt just because I told either Justice Kher on one occasion and Justice Deepak Mishra on another occasion and Justice Arun Mishra himself on a third occasion that they should not hear a case because of conflict of interest. So, so therefore we had to withdraw that petition. Now we have been permitted to file it in some high court, etc. And I hope that this focus and attention on this business of scandalizing the court will lead to reform in this law and in fact abolition of this this part of criminal contempt, which we have challenged on the ground that it's an unreasonable restriction on the freedom of speech. You can only impose reasonable restrictions by law, and this, I feel, is an unreasonable restriction on the freedom of speech. So thank you. That's all that I had to say.
Thank you. I guess in the order of speaking, we are now going to request Madam Arundhati to make her remarks.
Okay. Can you hear me?
Yeah, we can hear you. Fine. Thank you.
All right. So what I've done is I've written out something and I'll post it to you on WhatsApp. Greetings. It's a pity that in the India of 2020, in the era of minus 23.9, we should have to gather to discuss something as primitive as the right to free speech, surely the most fundamental building block of a functioning democracy. On the other hand, perhaps we have ceded the right to call ourselves one, because economically and socially we're on our knees. Over the past few years, our country has suffered from a series of artificially induced heart attacks. The sudden and unexplained demonetization, the roughshod introduction of the GST, the abrogation of Section 370 in Jammu and Kashmir, the attempts to ram through the Citizenship Amendment Act, the bungled COVID lockdown, and now COVID itself. Like often happens to patients with diabetes, these heart attacks have been silent attacks, masked by the pre-existing illness. That illness, in the case of our country, is the cacophony of relentless propaganda and the dereliction of duty by public institutions who have done little to stop the slide. And this includes the judiciary. Our heart is failing. And one of the doctors who, like the many academics, activists, lawyers, and scholars who are in jail right now, has been warning us for the longest time about our condition is Prashant Bhushan. For his pains, he is now a convicted felon. In his lengthy reply to the Supreme Court's 2020 charge of contempt of court, apart from the legal arguments challenging the accusation, Prashant Bhushan has listed a number of issues in which he maintains that the Supreme Court has failed by commission as well as omission to act as the guardian of the Indian Constitution, safeguard citizens' fundamental rights to life and liberty, and stem the slide into illiberal majoritarianism. Among these are the habeas corpus petitions by the relatives of some of the thousands of Kashmiris jailed around August 5th of last year, the internet siege, which in my opinion amounts to a crime against humanity, the Supreme Court's role in the execution of the National Register of Citizens in Assam, resulting in untold suffering and tens of millions of people being excluded from that list, the assault by police and right-wing thugs in the campuses of Jamia Millia Islamia and JNU, the mysterious death of Judge Loya, the scandal around the government's purchase of Rafale fighter jets, the court's refusal to intervene to protect workers during the lockdown, which resulted in horrifying migration on foot by millions as they walked hundreds and sometimes thousands of miles home to their villages. Prashant's reply affidavit also details several egregious corruption scandals, some of them involving judges of the Supreme Court who have been named. This is a monumental public document that ought to be compulsory reading for anybody seeking to understand how modern day India works, or, as the case may be, does not work. But now that Prashant has been convicted and punished, we cannot cease to pursue, question, and write about all of these things. We must follow his example and build on the courage he has shown. I'd like to raise one more important issue. Between its judgment holding Prashant Bhushan guilty for quote unquote scandalizing and quote unquote lowering the dignity of the court, and the quantum of punishment he has received, a symbolic fine of 1 rupee, there is a whole swampy universe. I'm glad that Prashant plans to challenge that judgment because as long as that judgment stands, it is a dangerous trap for those of us who are not well known Supreme Court lawyers from illustrious families. In recent years, others have been convicted of contempt of court too, among them Justice Karnan, a Dalit judge in the Kolkata High Court. He was convicted under a different section of the contempt law, interfering in the administration of justice, and sentenced to 6 months in prison. The Supreme Court lawyer Matthews Nedumpara was convicted of contempt of court in 2019 for, quote, contemptuous allegations and attempting to, quote, browbeat the court. He was given a suspended 3-month jail sentence and barred from practicing in the court for a year. Neither of these two were given the option of symbolic punishments. There is a fair amount of commentary in the social media about the different strokes for different folks, both in terms of the Supreme Court's judgment as well as the groundswell of support. Speaking for myself, I found the language used in the judgment that convicted and jailed me, not for 30 seconds, for contempt of court in 2002, intemperate, sexist, and denigrating. To be sure, the offenses that each of us are supposed to have committed are not the same, and Prashant's record of public service plays an enormous part in all of this. However, there is certainly a whiff of upper caste patriarchy in the air that must not go unremarked upon. In an unequal, caste-ridden, and overtly sexist society such as ours, it is the duty not just of the courts, but of everybody to be alert to all forms of discrimination. We cannot expect that the judicial establishment will volunteer to reduce its powers by repealing the section in the contempt law with its Victorian notions of scandalizing the court and lowering its dignity, even if it knows full well that the only way it can gain respect is through its judgments and not through this ridiculous law. Since the law is unlikely to be repealed, we must strive to make it redundant, not by deliberately and gratuitously insulting the court, but like Prashant, by speaking our minds about courts, judges, and their judgments conscientiously and responsibly. Thank you.
Thank you, Arundhati. Again, in the interest of time, may I now request Iqbal ji to please go ahead with his prepared comments, and then we'll come to the interaction.
I'm afraid I've lost the sound. Is there some reason why?
No, we can hear
Hello?
you. Yeah, we can hear you.
Can I be heard?
Yes, yes. We can hear you, Iqbal ji. It could well, it could be sometimes because of your wireless headset, but we can hear you.
I'm afraid I.
Now we've lost.
We can hear you, sir. You can go ahead. You
No,
can
now,
go ahead.
yeah, now I can hear you.
Okay,
I
so
can
sometimes
heard, right?
that Wi-Fi. Yeah, please go ahead.
All right. When a friend of mine learned of the constitution of the panel on this webinar, he said to me Do you realize that you are the only one of the three who has not been found guilty of contempt? And then added, ominously, yet. My only response could be, well, it's never too late. Among the freedoms protected by our Constitution, after liberty and life, the freedom of speech is undoubtedly the most precious. As so eloquently said by the Supreme Court in 1980, and I quote, 3 articles of our Constitution, and only 3, stand between the heaven of freedom into which Tagore wanted his country to awake and the abyss of unrestrained power. They are Articles 14, 19, and 21, unquote. Article 19 contains that precious freedom of speech, which is subject, of course, to reasonable restrictions. One does not realize how precious that freedom is until one loses it. Many of you may be too young to have experienced the dark, gloomy, and dispirited days of the emergency. It was a time like no other. Whispered dialogues in dark corridors, constantly looking over one's shoulder. Is Big Brother watching? Is Big Brother listening? Rajeshwar Dayal, a distinguished former Foreign Secretary in the Government of India, recounted his experience in Delhi. He had invited a half-dozen intimate friends to dinner when they spoke frankly and candidly about the dismal state of the nation. Perhaps too frankly and too candidly. The next morning, he received a call from a senior bureaucrat. Rajeshwar, you've been very naughty last night. You know you shouldn't be saying the things you did. Be careful. Who, Rajeshwar wondered, could be the informant? One of the guests? One of his staff? Or was his house bugged? The freedom of speech includes the freedom to receive information. During the emergency, this too was denied. The press was muzzled and there was no electronic media. Censorship was the order of the day, and we were told only what the government wanted us to know. In this gloom, the High Courts, and I speak with personal knowledge of the Bombay High Court, were a beacon light. In a case where the police commissioner had denied permission to a meeting to discuss civil liberties and the rule of law, the Bombay High Court, in a stirring judgment, set aside the order and permitted the meeting. The arguments of Nani Palkhiwala were a dissertation on liberty and the freedom of speech. Everything that could only be whispered outside was said loud and clear within the 4 corners of that room. And our spirits soared to hear MC Chagla at 75 to end an incredible speech in Ahmedabad with the following words. There is a saying that when the night is darkest, the dawn is not far. I see the night very dark. I am an old man and have not long to live. But you, younger people, will see the dawn. The dawn is bound to come. This country cannot go under. For thousands of years, we have survived invasions. We have survived all sorts of troubles. And I think we will survive both Indira Gandhi and her dictatorship. Why and how my father was never arrested and detained will forever remain a mystery. Today, we have an undeclared emergency. Freedom of speech is imperiled. The print media is compromised, and with some notable exceptions, we receive only such information as the government in power approves. The television channels, again, with notable exceptions, when they're not conducting a media trial or espousing the cause of the majoritarian party, do not afford any real news. And the Supreme Court has, in Prashant Bhushan's case, contrary to its record, weighed in, unfortunately, on the side of suppression rather than the espousal of free speech by the exercise of its contempt jurisdiction. It is a jurisdiction where the court is the complainant, the jury, the judge, and the hangman. The court chose to exercise that jurisdiction during the pandemic when matters of great moment were pending and not taken up, of which Arundhati just spoke, and these were challenges involving Article 370, electoral bonds, the Citizen Amendment Act, and most importantly, habeas corpus petitions. This extraordinary jurisdiction is exercised in extraordinary circumstances when the administration of justice is seriously prejudiced. Prashant Bhushan was to be punished as an example to all others who dare to criticize the judiciary. Were their lordships unmindful of those memorable words of Lord Atkin when he said, "Justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and respectful, even though outspoken, comments of ordinary men." Or the words of Lord Denning, "We do not fear criticism, nor do we resent it, for there is something far more important at stake. It is no less than freedom of speech itself." In a 108-page judgment, almost entirely the reproduction of passages of earlier judgments, we are told that by his tweets, Prashant Bhushan has shaken the very foundation of constitutional democracy and the confidence of the public in the judiciary. We must salute you, Prashant, for standing by your statements and not entering the usual defense that we lawyers take. I am not guilty of contempt, but if you find me guilty, then I offer my unconditional apology. We must salute you for not having succumbed to the repeated entreaties of their lordships to offer some expression of regret and give them the escape they so desperately sought. We must remember that in not apologizing, Prashant faced every possibility of incarceration and possibly suspension from practice. For who would have expected, in their 82-page sentencing judgment, the price their lordships ultimately put upon their own dignity would be but a rupee? And we must thank their lordships for having punished a senior lawyer who has done no more than expressed his dismay at the state of the judiciary and was willing to justify his comments. I thank them since, apart from receiving almost universal condemnation, the judgment has begun a debate that hopefully will result in a review of the law of contempt and uphold the right to responsible criticism, not only of judgments, but of the judges themselves. This review, one hopes, will be when the 11-year-old contempt case comes up for hearing before a larger bench and the present judgment overruled.
Thank you, Iqbalji. I take it that your initial comments are done. Well, those were very.
I'm sorry, I'm not able to, I'm not.
You can't hear me?
There's a problem on, can't be my speaker, can it?
It should be, because we can hear you. All right. So maybe you want to connect the Wi-Fi again, but let me, while you do that, if you don't mind, I will try to move on. Those were three very eloquent remarks by three very well-known, eminent speakers, orators, people from the judiciary and, of course, the writing world. Let me open up the interaction by bringing onto the floor uh, Charu Wali Khanna. She is also a well-known lawyer, advocate in the Supreme Court. She is a former member of the National Commission for Women, and she's written several books on law, especially as it relates to women. And she is one of those people who challenged the Articles 35A and 370 of the Constitution as they were discriminatory towards women. And that's her stand. But Charu, bringing you into this debate, and I would like to focus on the subject, freedom of speech and the Indian judiciary. I mean, we can always talk about freedom of speech vis-a-vis government and politics and which party is in power or not and what happened in the 70s, 80s, 90s and to now. But let's confine it to freedom of speech and the Indian judiciary, keeping in view and context the current state of things that happened. So Charu, I give you the floor for the first question or comments on what you've heard the three eminent people speak.
See, I'll restrict myself on the freedom of speech, the role of judiciary, and in the context of contempt. I'll take over from what Arundhati ji said. She said, and I want to ask this question. I would like Prashant to, expand more on it. She very rightly said, different strokes for different people. That is the impression. I'm talking because I'm a human rights activist and I work with people on the field. So that is the impression people on the ground, common uneducated people or common, I would say, workers have. And their concept of, they don't know the nuances of the law. Their concept, their role model of the judiciary is what they see in the films, which is Tariq pe Tariq. So taking over from there, uh, the perception that there is in amongst a large, I'm just questioning that amongst a large populace is that the court's been rather magnanimous with Prashant, and they've let him get away easily. If it was just because it's him, if it was us, we would have had to go to jail.
Oh, God.
And Prashant, you must accept that we've seen this daily in courts. Every time a matter is dismissed and the court feels it's frivolous, though a lawyer may have, prepared for it, spent money, effort, and then they'll suddenly say, no, it's frivolous, and we will, you have to pay a cost of 50,000. And then he begs and he pleads, and Millard, he goes, and then they say 10, and then again he has to come just before mentioning. So, I mean, that's what I'm trying to say. So the concept, I think somewhere in the mind, the perception has been reinforced that there are different strokes for different people. And the second very important thing which Arundhati raised was the upper caste patriarchy. I mean, why was Justice Karnan? Just because he was a Dalit? I mean, there was a very, very strong feeling amongst the populace of being kind of, vilified just because you're a Dalit. And I think, Prashant, you were very much a part of that campaign. So on the flip side, which is taking from what Mr. Ipal Chagla said, that escape desperately sought. So on the other side there, because I'm working with victims of sexual violence and a lot of abused women, and they feel that, isko to ek rupaye ka ho gaya, jisne hame kiya, he'll also get away with it. So people will be emboldened to commit crime, to violate the law and say, okay, we can get away with it just for 1 rupee. I'd like Prashant to comment on this, please.
Thank you. Thanks for the question.
So, you said the discriminatory, you sort of underlined the issue of the discriminatory attitude and sometimes
Positive discrimination in your favor.
sometimes caste bias, etc. of the judiciary. So, firstly, I want to make it clear that yes, the attitude of the judiciary is often dependent upon the power of the person who is before them. And that is also depending upon the power of the lawyer who's before them. So even we see that very powerful, very well-known lawyers are treated differently from very junior lawyers by several judges, not all, but by several judges. And also these powerful business folk uh, and powerful politicians are treated differently from ordinary poor people. By and large, we have seen this kind of discrimination. But I do not agree that in this case, in my case, they were influenced by my status or standing, but more, I think, by the public reaction that happened. Now, the public reaction that happened may also have been because of whatever is perceived to be my standing, etc. Uh, uh, and so far as Justice Karnan's case, because this issue comes up again and again, I don't think that the actions of the judges were influenced by the fact that he was a Dalit. You see, these were the 7 senior-most judges of the Supreme Court who heard his case at great length, and thereafter passed an order not only on the basis of the absolutely wild and scurrilous allegations that he was making against a very large number of Supreme Court judges without any basis, but rather mainly on the basis that he was passing orders from his residence, judicial orders or seemingly judicial orders, saying that arrest these Supreme Court judges and produce them before me in handcuffs. I mean, so it was direct interference with the administration of justice. And this parallel that is being sought to be drawn by many people between my case and Karnan's case, or the discriminatory attitude of the courts in these two cases, is certainly, in my view, not based on the caste of Justice Karnan or my upper caste, etc., but it is rather based on completely different issues and for different reasons. I agree that the court's final softness towards me, or this token penalty, was influenced by all kinds of considerations, such as the public reaction, the statements of judges, the statement of the Attorney General, etc. All those things must have influenced the court, because if you read the judgment, it's a pretty vicious judgment against me. It holds me guilty of all kinds of things, compounding the contempt, very egregious contempt, and so on. But when it comes to the end, in terms of sentencing me, they come down to a token sentence of 1 rupee, and failing that, 3 months in jail and being barred for 3 years. So it's rather incongruous, but that incongruity is on account of what happened in the public space.
Okay, Arundhati, you want to answer?
Yeah, no, I totally agree with Prashant about why Justice Kannan was arrested. I mean, was held in contempt, but whether he deserved a sentence of 6 months in prison, I don't know, because there was more to it than just those things. He was constantly speaking about feeling discriminated against because he was a Dalit, not just on this occasion. But my point was not to draw parallels between these two, because as I've said in this piece, Prashant's record of standing up for people is so long that is why he got such a lot of public support. But I still think that these prejudices function in courts. We know the disproportionate number of Muslims, of Dalits who are in prison, who have faced capital punishment. I would say that, certainly if, I would go so far as to say if Prashant had been a woman, if Prashant had belonged to a minority community in this atmosphere, there would have been a kind of viciousness which would have been acceptable. So the cheeky woman or the cheeky minority person standing up to question this pillar of democracy would have played out. But this is not to take 1 second away from what Prashant has done. He's a friend of mine, and we have stood by each other through thick and thin for a long time. So this is nothing to do with him. It's to do with the way courts function.
Iqbalji, I'm sure you have something to add, but let me, before you answer this comment or a question from Charu. Sorry, can you hear us? Can you hear me? Hello, Iqbalji, can you hear me? I don't think he can hear us. Can you hear me, Iqbalji? All right. Let me, I will come back. I will come back to Iqbalji. I have a question which has been sent to us for you, Prashantji. Let me read it off because it's come on WhatsApp. It's from a member of our club, a journalist member of our club, and his name is Pankaj Yadav. A slightly longer question, but I'll read it very quickly. The topic of today's webinar is freedom of speech and the Indian judiciary. Every other day, we get to hear different kinds of stories coming out of the apex court. Now, the latest one being a strongly worded letter from the Supreme Court Bar Association President Dushyant Dave, who has decided to boycott all official functions organized by the top court until his tenure ends. The reason: he was denied his right to free speech or deliver a speech at the function for Justice Arun Mishra's farewell. In his letter, President Dave stated that the apex court had reached a stage where judges are afraid of lawyers. This incident came right after your, the judgment in your case. So he wants to ask you, what's your take on all this happening in our country's topmost court of law?
Yes, unprecedented things have happened. I mean, if you see the kind of write-ups that have appeared about Justice Arun Mishra on the eve of his retirement, even the article written by a retired High Court judge today in the Indian Express, Rekha Sharma, who at the end of her article says, and then she says, I quote Oliver Cromwell, who told Parliament, in the name of God, go. You have been here far too long. So this kind of uh, reaction to the retirement of a judge of the Supreme Court has not happened before. We are seeing unprecedented times because we have seen an unprecedented judge, a judge who has openly praised the Prime Minister in a public sphere. We have seen that judge openly invite BJP leaders to his residence, even at a time when those leaders' cases are pending before him. So, unprecedented things have been happening. And what happened in the function, the farewell function yesterday, I have no doubt that it was deliberate, that the registry was told to not to allow Mr. Dushyant Dave to speak, and that also underscores the problems in this video hearings that we have today. These are not hearings which can fairly substitute for actual physical hearings, because very often people cannot connect, they are not unmuted, they can't be seen, there is crosstalk, etc. And therefore, that was one of the issues that I had raised in one of my tweets about the motorcycle. I said that at a time when the Chief Justice keeps the Supreme Court in a virtual lockdown, due to COVID, at that time he's seen in a public place on a motorcycle with so many people without a mask. So I was trying to express my anguish at the incongruity of this all. And particularly at keeping the court in lockdown. Now, in response to that, in the judgment, they have said that no, in video hearings, we have disposed of so many cases, etc. If you compare that with the number of cases that would have been disposed of or heard if the court had been regularly functioning, it would have been about 10 times. Only one-tenth of the cases that are normally heard were being heard during this video hearing, etc., and that too in a very, very unsatisfactory way. So, it's unfortunate that all this is happening, and there is, as I said, these are unprecedented times, and unprecedented things have been happening.
Just a follow up on that answer or that question. I mean, in the case of in your case, Prashantji, there were other two judges on the bench. Why don't they dissent? I mean, don't they dissent, or are they not heard, or their dissent doesn't matter?
That was rather root of the matter. Mr. Iqbal Chagna would be better placed to answer that question if he is hearing it.
Not only the judges can answer.
No, Iqbal, I mean, we just want to know. I mean, the public, I'm reading off of what, there are hundreds of people watching this on Facebook Live. So this is a very, very interesting comment that was made by V.S. Lakshmanan. And I thought it pertinent to bring it up with you. Iqbalji, you want to take that? Maybe Prashant.
Yes, I'm finally back again with all of you. No, I agree. We've had instances here of junior judges dissenting from a senior judge. And I see no reason why, whatever Prashant Bhushan has rightly said about Arun Mishra, there are two other judges sitting there. Surely they, and I've come in a little late. I heard part of what was said earlier. Let's understand this, that what the Supreme Court has delivered a 102-page judgment castigating Prashant Bhushan as being an absolute villain, that there is absolutely no mercy to be shown to him. There's no magnanimity. And yet, when it comes to the sentencing, in a 82-page judgment, again with all sorts of things, how badly he has behaved, ultimately they lost their nerve. They did, because of the public outcry, the outcry of former judges of the Supreme Court who said this is disgraceful to do all of this, from journalists, from editors, from historians, and various people. And I think they just lost their nerve. But I agree that the two other sitting judges ought to have asserted themselves and said that we will have none of this.
Well, thank you. I will now ask, I have a couple of very interesting questions to ask, but I have reserved them for later because I do have a very eminent panel of my colleagues. Sanjeev, you want to go on on the question?
Okay, thank you. Thank you very much. And
Sanjeev,
thank
by the
you.
way, is the hang on, Sanjeev. I'm sorry I didn't introduce you. Sanjeev is the bureau chief for Reuters based in Delhi. Sorry, go ahead, Sanjeev.
Thanks very much. Thank you, Manish.
Oh,
And yeah, thanks for our guests. I was just thinking, just broadly. I mean, all three of our guests have laid out the situation that we are in, the state of democracy, our democracy, and the freedoms. An undeclared emergency, as Mr. Chagla said. Can I ask? I just want to throw it forward. Can I ask? All three of you, do you not see any light in this tunnel? Is there any sign of resistance building up? I mean, did we see some of that during Prashantji's struggle for the last? Do you see any signs? There was quite a amount of public support. Is there resistance building up finally, as you said, about 6 years on? Thank you.
Arundhati, why don't you take that?
Well, I think that what has happened in this case with Prashant has lifted people's spirits and stiffened people's spines to some extent. I was amused to see that, the kind of lynch mob leaders who masquerade as TV anchors were not battering him the way they normally go for people who stand up. That was a sign. There have been some, good moments where the Allahabad High Court has released students who've been unfairly arrested. The Delhi High Court has released, people who've been arrested unfairly and ridiculously under, at least acquitted on certain cases, not released, let's say. So there are little pinholes of light, but as soon as there's a pinhole of light, they move to board it up very fast. And I would say that, we can't be waiting for hope. We have to generate that hope, which is why I think that Prashant's affidavit is such an important document, because it gives you a blueprint of the things that we can raise with facts on our side. And really, you have to make these laws redundant. We have to show courage. We have to not be afraid in some ways. And when they see that we are not afraid, there will be a backing off. This is what I feel. Studying, fascism in some detail. The point is that you have these institutions that are almost, in the thrall of something which cannot be described as sane right now. And we have to show sanity, we have to show political will, and we have to show courage. And I think this moment has given us an opening, and we have to follow it through, because nothing is going to fall into our laps. It's up to us to generate the hope.
May I say something here as well?
Please do.
I think we have to realize one thing, that in our system, when the Supreme Court speaks through 2 judges or 3 judges, the Supreme Court is speaking for the entire court. Now, this very often, as in the present case, I think, to say that the 3 learned judges who delivered this judgment, who held him guilty of contempt and punished him for it, I'm not sure whether that's the echo of all the judges sitting in the Supreme Court. We must realize that there are 31 judges, that there are judges of great independence, great ability, who I have no doubt do not share the view of the 3 judges. And that is where the light at the end of the tunnel, as I see it, is that a future sagacious court is going to set this right and say that, no, we will have none of this, that things must change, that you can't have a senior lawyer of great reputation who's done the things that he's done, that he should be victimized in this manner because he's not liked or whatever it is. So that's my take on this.
So I'll just add one thing, that one of the good outcomes of this case has been that it has kind of brought a focus spotlight on the role of the Supreme Court in the last 6 years. And it has brought that issue up for a lot of public discussion. And I think that spotlight on its record is likely to, and I think it is already making the court and even the high courts behave somewhat differently. See, that comment was meant so that the court corrects its course that it has taken broadly taken during the last 6 years, barring a few exceptions. That is, failing to protect democracy, fundamental rights, and the Constitution. The other positive outcome that I see is that it has, as Arundhati said, it has stiffened the backs of people. It kind of became a freedom of speech moment and movement, this contempt case. And a lot of people said that we are also saying the same thing. Some of them said even more trenchant things and dared the court to punish them also for contempt. So as she says, if enough people get up and say that, all right, we are not afraid of going to jail and we are going to say what we need to say and what we want to say, then they will not be able to suppress this free speech and the voice of the people.
Since we are on that subject, and I heard one of you mention one among the three of you mentioned about India as being only one of the few countries where we have this issue of contempt of court. You see, India, there is a manner in which Supreme Court judges are selected through the collegium, etc. In the United States, the world's other big, great, lovely democracy, the president nominates, and it depends on whether the president is Republican or Democrat, and naturally they look at who is going to serve their purpose and nominates whoever in Supreme Court. And a lot of judgments and decisions of the Supreme Court are swayed by how their philosophy and ideologies. So I don't think it's right to say that India is probably the only big democracy in the world where governments or politicians might have a say or influence on the way things work in court. And I want to bring this up, and I hear from you again and again, Prashant ji, just that last 5 years, last 6 years. So do you think the Supreme Court and
Oh Lord, there we go again.
No, we can't hear you. I can't hear you.
Your mic is muted. Yeah.
Okay. I'm sorry. I'll cut to the chase, get to the point very quickly. Is in the United States, the president nominates, and if the president is Republican or Democrat, he picks the kind of judges he wants for the Supreme Court of the United States. And naturally, then there is that political influence on the judiciary. In India, it does not happen that way, at least not publicly, at least not the way it happens. And also, I heard that in the last 5 or 6 years, a couple of times you said that things have happened which are, sort of the influence of politics on the judicial system as such, not just the Supreme Court, but other courts too. But it has happened in the past in India, where politics has tried to influence the judiciary or democracy or take away democratic rights. Or are we completely wrong? Are you saying this is only in the last 5 or 6 years? I mean, I hear that too strongly to start it.
No, you are right that the attempt of the government to influence judges and pack the Supreme Court with their own compliant judges has happened earlier also. Mrs. Gandhi's time, it happened. Hansraj Bharadwaj was famously known to say that we will only appoint judges of our kind, of the kind who subscribe to us and who are committed to us. But the difference in the last 5-6 years and the previous years has been that, except during that period of the emergency, we have, after the emergency until 6 years ago, we have not seen the kind of whole-scale assault on democracy, on fundamental rights, on the rule of law, and on civilization itself that we have seen in the last 5-6 years. In the last 5-6 years, we have seen a very systematic and brutal assault on every institution of democracy in this country, on every civilized value in this country, on trying to erase the difference between truth and falsehood, on trying to continue with just propaganda and perception building, etc., on trying to destroy scientific temper, on trying to destroy our university. This kind of assault on our democracy is totally unprecedented. There is no parallel for this ever in our history before. This is absolutely unparalleled, and that is why the role of the Supreme Court during these 5-6 years was extremely important. And they're failing to perform that role and failing to protect this brutal assault on democracy is what distinguishes the previous years from the last 6 years.
Okay. I guess the Arundhati and Iqbalji might want to comment on that too. Any comments?
Arundhati, are you going in first?
Sure, no, you go ahead.
Yes. I agree entirely with Prashant that what we have seen is all our institutions are being debased. And where this is where we've always in the past turned to the courts for protection to set right what we believe is really going wrong. The Supreme Court, unfortunately, in the last few years has let us down. And I think this is what Prashant is talking about with certain, it's a matter of judges who are being given sensitive cases to decide. Others are being sidetracked, not being given any work, except as one of the Supreme Court judges told me that he was hearing criminal bail application appeals, another was hearing commercial matters, all very well, but it is a constitutional court. And those sensitive matters were those not being given to the judges. And this is what I think is really has been the problem of late. That was never so before. As Prashant rightly said, there was a time, Kumaramangalam famously said in Parliament, that we will appoint only forward-looking judges, judges who look not to the Constitution, but to the government of the day. Now, that was a history. There were challenges. Supreme Court heard challenges from. I was one of the petitioners, in fact, in one of the transfer cases, and well, ultimately, we thought we were doing the right thing, namely that leaving it to judges to appoint judges. A judge of the Australian High Court, which is their Supreme Court, he told me, he said that it's the most absurd and ridiculous thing that you're doing. How can you ever trust your judges to appoint judges? We would never think of it. And nowhere in the world do judges appoint judges. It is always the executive that appoints judges. So, and the collegium system has failed. We had this example in December, 2 judges who are recommended for the Supreme Court, and in January, collegium, less 1 judge, suddenly changes its mind. I mean, this is not the way to instill confidence in our judiciary.
Arundhati, please.
Yeah. Well, I think, that basically, eventually, we have to look, it all boils down to a question of ideology, because neither of these regimes, if you look at just the moral values or the quantum of, let's say, human rights violations, you can make an equivalence between them. I mean, the massacres of people in Kashmir happened during VP Singh's regime. There's never been a day since 1947 when the Indian army hasn't been deployed against, quote unquote, its own people. Governors appointed, governments toppled. All of that has happened. Riots, killings, encounter killings, all of that has happened. But here we are looking at an ideology that is now dedicated and moving towards making the Constitution nonsense, not rewriting it, but simply making it redundant, of trying to create a mob fury on the street, as well as infiltrate every institution with this ideology, which is essentially that India is a Hindu nation. So when you look at the ideology of secularism, whether it's pseudo, whether it's false, whether it's hypocritical, the point is nobody then was saying India is a Hindu nation and all the minorities have to live under this regime of terror, you know. So now with this ideology, everything, whether it's cinema, whether it's the courts, whether it's the intelligence agencies, often whether it's even the army, you're looking at an ideology which is fascist taking over. People flinch at the use of the word fascist, but that depends on whether you describe an ideology or you want to say fascism only happens once what Hitler achieved in Nazi Germany has happened. No, this ideology makes that possible. It may not happen. We may resist. We may find ways of toppling it. But I think ultimately this question is one of ideology and of value. And do we believe that this is a country in which almost every person in this country belongs to some kind of minority when you look at caste or religion or language or ethnicity, you know? So do we believe in honoring our minorities, or do we believe in majoritarianism? And after that we can look at how they've stacked courts. Everybody has done it, stacked courts or changed syllabi or put in the people they prefer where they prefer. But what is the thinking behind those moves is what is really important.
I would like to stick to the subject of freedom of speech and the Indian judiciary. I think we are sort of, I mean, correct me if I'm wrong, but I'll ask my rest of the panelists to please put forth their question. But is this, I mean, here is very strong statements, and I'm trying to understand because this is going out to the public. This is a very strong statement coming from all of you, if I'm not wrong, that we are looking at the freedom of speech in the context of the huge political influence, almost the running of the judiciary by the politics and ideology. But I will leave it at that and let you answer it later. Let me come to our other panelists. I would request Simran if she has a question or a comment.
Yeah, I just wanted to ask Prashant Bhushan something.
I've lost you.
Can you hear me?
I can hear you.
Go ahead.
Yeah. So my only question is that, what Manish was also talking about, you have this constant tension and strain between the judiciary and the executive. And I don't think this is something limited to only India. We see this happening in almost all the major democracies in the world. And if you look at the Indian judiciary, someone like me who's in the media, you also get a sense the judiciary is acting as if they are more of individuals. They are also looking at post-retirement jobs. They are looking at other things rather than just doing a very sacrosanct function that used to be the judiciary. What do you think is the way out? How do you separate this tension which the judiciary will always have from the executive?
Yeah, you see, the judiciary's job is to protect the constitution, democracy, and fundamental rights of people from primarily the assaults of the executive and to some extent of the legislature. And that is why the judiciary needs to be totally independent. So this view that was espoused by one former Chief Justice that the judiciary and the government need to work together, this is a totally wrong-headed view. The judiciary is always supposed to be a check on executive power. And that is why there should be a healthy tension between the judiciary and the executive. And for that, we need an independent judiciary. Now, there are many ways in which independence of the judiciary is being compromised. Of course, the Constitution has ensured that the executive cannot really do anything to sitting judges except impeaching them, and that's a very difficult process we have seen. But what they are doing is luring many of them with post-retirement jobs. They are also now, they've started interfering in the appointment of judges by not notifying the appointments of those that they do not like. They sit on those recommendations for years altogether. And now a third method is now being used. You see, this government is known to use the agencies, the IB, the ED, the income tax, the CBI, etc., against political rivals, against the media, against business houses as well. And now we are seeing that probably that these agencies are also being used to bring the judiciary to heel or judges to heel. And unfortunately, you see, what is happening also is that the power of the Chief Justice is so enormous, the power of master of roster. So they can decide, they can get virtually every politically sensitive case decided in the manner in which they want. This is the issue that the 4 judges raised in that press conference. Therefore, if you can somehow control the Chief Justice, you virtually control the entire judiciary. And that is why we had raised this issue, that this power of this one person having this enormous power as master of roster to decide and to fix any case that he wants before any bench that he wants, this is not healthy at all. And this power should be vested with at least a collegium of senior 5 judges of the Supreme Court.
Any other comments, or should we? I know Venkat wants to.
This is not a very recent occurrence. Can I be heard?
Yeah, please.
Yeah, it's not a recent occurrence. I remember many decades ago being invited to speak at a seminar in Bangalore, the Karnataka Commission, and the subject was on post-retirement allurements being given to judges, particularly of the Supreme Court. And a very senior bureaucrat who just retired, he said, "Do you know, I am witness to sitting judges of the Supreme Court visiting South Block and North Block looking for post-retirement jobs. This is while they were still sitting judges of the Supreme Court. This is something that has to be stopped. It has to be done by whatever a law that's enacted, that judges ought not to be offered any post-retirement allurement. It does affect their judicial life, their judicial conduct. It's too much to expect that certain judges who have refused and said that we will not accept any post-retirement job. They're few and far between. The others are all looking for it. And the only way that you can get that is then if you decide matters in favor of the government.
You know, this lure and this whole process of luring people either in the executive or in the judiciary or even in parliament is a subject in itself. But let me first come to Veera. Veera, do you have a question for the special guests?
Thank you, Munish, and thank you, Prashant Saab and Arundhati and Iqbal, not for your deep as well. Can you hear me clearly?
No. You're muted.
So, just I have a question.
Yeah.
No,
we can hear you.
We can hear you, Veera. Go ahead.
So, just a quick one. I wonder if the cacophony of propaganda, as Arundhati describes, hasn't deafened the judiciary. And if it has, then I think freedom of speech in the larger context becomes relevant even within this topic of freedom of speech in context of judiciary. But leaving that process aside and not being tempted to go there, I have a question to Prashant Bhushan in terms of, the fact that, when I hear you, I feel that the sense that you had to go through this process of punishment, which is the punishment and the 1 rupee liability, was possibly, at least in your opinion, correct me if I'm wrong, more the product of the insecurity of an individual judge rather than that of the insecurity of the institution as a whole. And if it was the product of the insecurity of an institution like it has been in several other cases, an institution which is insecure about its credibility, would you have gotten away this easily or with this much, with a sense of triumph? That is number one. And the second question that I have to both of you, both Arundhati and to Prashant, is it more difficult to be contemptuous to the judiciary, or is it more difficult to be contemptuous to the cacophony of propaganda? And as we go along, are we in desperate need of an algorithm to support freedom of speech if you have to be heard, by the entire population, irrespective of a political divide?
So I'll answer the first part of your question. That is whether my tweets made a particular Chief Justice insecure, or whether they made the judiciary or all the judges of the Supreme Court insecure. I think one of the tweets made primarily the Chief Justice insecure. That is the tweet about the motorcycle and the court being kept in lockdown. But the other tweet was a more general tweet, so it also referred to the last 4 Chief Justices. And in some way, it would have hurt many more judges of the Supreme Court, particularly those who had participated in many of those judgments, or rather abdication of responsibility in all those cases which were critical for the defense of democracy. So, but ultimately, you see, this token punishment was the result of this public outcry, I feel. The rest, Arundhati can take the second part of your question about cacophony, etc.
So, okay. So, the question of freedom of speech now mixed in with hate speech, now mixed in with fake news. An interesting example of the mess it created, I think, was when the Supreme Court decided to intervene almost as an executive, in an executive way, in the process, in speeding up the process of the NRC in Assam. And many of the decisions, including the ways in which laws were changed, had to do with this kind of propaganda that came out of, oh, there are 1 crore illegal migrants, the country is being eaten inside out by termites, all based on nothing but propaganda and speculation. So now, and even as Prashant keeps saying, the public pressure on the courts, because in his case, of course, it's also when people came together and a lot of the media actually held up this cause, which was a welcome change from what could normally happen. So now, I mean, this question of free speech, the right to free speech auctioned off to the highest bidder, fake news, to me, sometimes I feel like we need to really think about it. I mean, how do you make an algorithm, as you're saying, when trying to find your way through a forest of social media, fake news, real news, everything? It's like walking through a forest trying to find your way out when the trees are also walking around, and the mango trees are bearing coconuts and the lime trees are producing pineapples, and you just have lost your coordinates altogether. We do need to sit down and have a good think about how are we going to manage this cacophony, because it's becoming toxic and dangerous, and of course life-threatening, not just to our democracy but even to individuals, who they decide to pick on. And the kind of osmotic layer between the court and this fake information, as I said, it's an osmotic layer, but it needs to be looked at very carefully.
Iqbalji, do you want to comment?
No, only this. That's very unfortunate, because we have legal commentators who described the Supreme Court as an executive court. We've had an eminent historian who has gone so far as to say it might be seen as a collaborationist court. These are now the serious matters which I think require deep introspection by the Supreme Court itself. And that's the comment I want to make.
Okay. Venkat, do you have a question or a comment? You're the only one who hasn't spoken. Unmute, Venkat, unmute yourself.
Sorry, yeah.
Okay, great.
This is a larger question. Justice has become beyond the reach of the average citizen of India. Lawyers are too expensive. ordinary people cannot afford them. And in any case, you have so many cases pending in the courts. You have 3 crores and 30 lakhs of cases pending in all courts in India, more than 65,000 of them in the Supreme Court, and 45 lakhs of them in the high courts. I think this is absolutely scandalous. And people say that primarily this is because of the lawyers. A lawyer takes more than one case and is always seeking postponement. I think there should be something that ought to be done so that the average citizen gets justice. And the fee the lawyer's charge has become absolutely ridiculous. If you can afford to hire an expensive lawyer, you can do anything in this country and get away with it because of the lawyer. Prashant and Iqbal, what do you have to say about this, and what can we do to ensure that courts do not keep so many cases pending and justice becomes reachable to the common man in our country? Thank you.
This is a larger problem of judicial reforms. So we have a problem at many levels. The first level, the courts are not accessible to common people because they can't afford lawyers at all. So they are helpless. If a street vendor is charged with a crime, he is helpless. He just stands with his hands folded before the judge or before the police officer. He can't even arrange for bail for himself. So we need to firstly make the judicial system accessible to the common people without the help of lawyers, and the Gram Nyayalayas were supposed to do that. That act came about 10 years ago, but it has not been effectuated. It needs to be effectuated. We have filed a petition in the Supreme Court, which is now taking it up. Because those were supposed to be simplified courts which people could access without formal CPC, CRPC, etc., without the help of lawyers. Secondly, we need to have more judges and better judges. So the number of courts need to be increased. The quality of judges need to be improved by having a proper judicial appointments commission at both levels, one for the lower judiciary, one for the higher judiciary. Should be full-time bodies which should lay down a criteria for selection like it is done in England, and thereafter have a scientific way of evaluating people on that criteria, and all that needs to be done transparently. And along with that, we need to have a robust system of judicial accountability by way of having a independent judicial complaints commission, a full-time, high-powered independent judicial complaints commission. All those reforms need to be done. Unfortunately, neither the government nor the judiciary is really interested in these reforms. Unless the common people who are the real consumers of justice, who are the real stakeholders in the system of justice, unless they mount a strong movement and a campaign around this, the government and the judiciary are not going to pay heed to that. All that needs to happen.
Iqbalji?
I fully agree that the mounting arrears is the greatest blot on our judiciary, and I think you're right to say that all of us, in a sense, are responsible, lawyers included. It's a curious feature that there is a thing like face law, people of stature, particularly in the Supreme Court, who can get their matters taken up earlier. And those that have been waiting and waiting and waiting, it still remains. It is largely a court which is an interim court. Mondays and Fridays, referred to as harvest days, an ugly term, but it's true. And these are the lawyers who are reluctant to take up matters on Tuesdays, Wednesdays, Thursdays, which are final hearing matters, the development of the law. The answer, as Prashant just said, appointment of good qualified judges. But it's not only good qualified judges, you have to make it attractive enough. The salaries have to be increased exponentially. You can't keep it at what it is. We had once mooted that it should be completely tax-free. Not only do you then command the best talent possible, but you also put beyond temptation any possibility of any judge wanting to be lacking in integrity. These are perhaps some things that can be seriously considered and done.
I just wanted to bring this up because, in the context of freedom of speech and the Indian judiciary, I guess, we've gone all over the place, but it's fine. I mean, a debate and discussion is always welcome. But you hit the nail on the head, Iqbalji. All these things cannot be considered in independent silos. And it's not to say that a Supreme Court that evolves with judges over 30, 35 years of service suddenly gets influenced in 5 years. They're not drawing consensus. They're not working. So it's something that's not worked in our system. The judicial reforms, as you said, Prashantji. I mean, they were supposed to have been instituted 10 years ago. So there is a reason why the politics, the executive, and the judiciary behave in their own ways to run the system the way they want. I guess. But anyway, we are way beyond our time limit. We are at 6:19 p.m. It's 1 hour 20 minutes into the debate, and I just want to quickly round up by asking Charu particularly. You've heard the whole debate, Charu. Any comments? Any last questions before we wind up? You have to unmute yourself, Charu. You have to unmute yourself.
I thought I couldn't hear.
Unmute.
We can't hear you, Charu.
Microphone.
Freedom of
Yeah. No, I think it's rightly been said. It's a time for judicial reforms, and the system is badly decayed. I mean, we have an ancient, almost a Victorian system in which you go, my lord, and they are not some majestic lords. They are the custodians of the Constitution. So, I mean, we need to develop a system like that. Though I don't agree with what just Mr. Chagla said about they get very good, let me tell you, benefits. They're not corporate heads. The kind of benefits they get, not only the salary, look at the perks. I mean, everyone would give their left or right arm to be a judge. So I think they're in a very, very exalted position. And it's time that, they became sensitive to the needs of the people. And it's not, people don't need to fight for their rights as they are. And they're struggling. Because for the common man, like Prashant said, that the vendor, he just folds his hands. He wants a matter. He'll give the money to the police or whatever. He just wants the matter to be over. He can't leave his livelihood every day and go to the court, just to follow up the matter for years. So it's very unfortunate. The system is definitely and I don't think we can blame any government. It's just that there has to be a tension between the judiciary and the executive. That's very important. And it's for the judges to it's for the human beings. I mean, if someone tells me to do something wrong, it's my conscience. I will not. So why should you say that they are coming under pressure? Nobody should come under pressure. You have only to uphold the Constitution. That's my limited view.
Any I'll round off by alluding to what I think one of you said. You talked about repealing Articles 14, 19, and 21 of the Constitution. My question to you, as a layman, as a journalist, and as just somebody who doesn't know the law that well, but understands that we live in a very humongous country with all kinds of people, with stratification of society, as Arundhati says, and as several people refer to. Are we ready as a country to simply say we are going to repeal any contempt articles and sort of leave it to the public to handle things as they want to? I mean, are we ready? Do we have, as literate, well-read, luminaries, sensible, smart, conscientious people like you all over the country to say, let's just go for it. Let it be freewheeling. All three of you, please comment.
So if I might come in, as I said, contempt is in three parts. Civil contempt, disobedience of court's order, that should remain. There's no difficulty with that. Criminal contempt, also the interference with the administration of justice, interference with court proceedings, that should also remain. No difficulty with that. The problem is with the third part, which is scandalizing the court, which happens due to somebody's outspoken comments about the functioning of the judiciary. That part should go. There is no reason for that, because to say that public confidence in the judiciary will disappear if you do not punish people for even the most scurrilous comments, that's totally wrong. People can see if a comment is totally baseless and scurrilous, etc. And confidence in the judiciary comes from the actions of the judges, their judgments, and their behavior. It's not engendered by suppressing people's voice through this law of scandalizing the court, etc. This part should go. There is absolutely no justification for this.
Arundhati?
I completely agree with Prashant, and in the affidavit under which I was convicted in 2002, I said more or less the same thing. That the courts, I mean, of course, the Supreme Court of India is one of the most powerful courts in the world, which sort of micromanages people's lives. And the high courts are also very powerful courts. So any scurrilous comment, of course, it's not that they'll just go scot-free. They have recourse to everything that ordinary citizens have, defamation and so on. But to have an institution which is micromanaging your life, but that you cannot comment upon, is just, you can't call this a democracy if that is the case. So I do think that section of contempt of court law is colonial, it's Victorian, and it has to go.
Iqbalji?
Yes, I think we have to strike a balance. Nobody for a moment suggests that comments which are utterly scurrilous in respect of the judiciary ought to be condoned. Nobody for a moment suggests that. But that balance that has to be struck is this oversensitivity. It can't be done in that way. It can't be that judges have become so sensitive that they say, you can criticize our judgments, but don't for a moment criticize us. If there are what is whispered in the corridors of the courts, whether the High Court, the Supreme Court, all of that we all are privy to. When we in Bombay moved the resolutions against 5 corrupt judges, we did it on the basis that it was our collective experience that showed that they were in fact corrupt. Now, well, at that time, justification was not a defense, but nevertheless, we moved forward. We fortunately had Chief Justice Sabyasachi Mukherjee, who took a very humane and correct view of the whole thing. But it is ultimately that balance that has to be struck. By all means, the law of contempt must remain, but not, I think as Prashant is right, that it can't be in respect of what, if it truly affects the administration of justice, yes, but not comments about judges. That, I think, ought to go. And that is the reform and the review, which I hope a future court will bring about, if not by an amendment. Certainly not an amendment is not going to happen, but it can only be done judicially.
Thank you. So thank you very much for this discussion. I'm sorry I sort of got into the flow of things and didn't introduce my other colleagues here. I introduced Charu, I introduced Sanjeev, but Mr. T.M. Veera Raghavan is a consulting editor for the Synergia Foundation, and our dear colleague Simran Sodhi is a columnist for the Khalij Times. I thank you all, my colleagues. And I would now move to Venkat to formally offer a vote of thanks to our special guests before we close.
Well, we had a very interesting discussion. Thanks very much, Prashant. Thanks very much, Iqbal, and thanks very much, Arundhati, and also the panelists who represented the FCC, Sanjeev, Nish, Simran, Charu, and Veera Raghavan, who is joining us from Bangalore. We are trying to reach out different parts of the country, and we invite special guests to take part in this. And we had a very interesting discussion, and we were enlightened a little more than what we knew earlier. And what all these discussions, webinars, and other discussions we had at the club, the videos of these are a part of our archives in the FCC website, and also you can see YouTube on YouTube. I want to announce that on the 17th of this month, we will be joined by Mr. Ban Ki-moon, the former Secretary General, to discuss the United Nations at 75. Is the world better or worse? So I'm confident all of you are interested in that, and you will be joining us. Thank you very much, ladies and gentlemen. Good night for now.
Good night.
Good night.
Good
Thank
night
you.
and
We
thank
close
you.
the meeting.
Thank you.
Close the meeting, Anil.
Thank you.